Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with another breaking news update for you in the Blake Lively versus Justin Baldoni legal universe, which is what we're calling it now because there's so many parties involved and so many different moving parts. I'm going to give everyone a minute to filter in here so we can read this new filing where Ryan Reynolds, as we know, husband to Blake Lively, has actually filed a motion to dismiss Justin Baldoni's suit himself. And we'll go over that. It's about 30 pages. It's not going to be too long. While we're waiting for people, I just wanted to add, there are lots of stuff going into Pacer today about notice of appearances from lawyers that we already knew were representing Justin Baldoni, Wayfarer, etc. And the reason for that is there were like filing errors. So nothing really intense is happening with that. It's just like they're just filing paperwork basically. But I did notice last week a commenter had pointed out to me, hey, Brian Friedman's nowhere on the docket anymore. And I was like, what the heck? But I didn't want to say anything because I was like, it's probably just an oversight or something somehow. And apparently it was like a filing problem. I don't know why I'm stuttering right now, but yeah. Okay, let's not waste too much time. Back to work and work a little late after this. So let's see. I can try to zoom in a little bit more. Hopefully you guys can read that though. All right. Defendant Ryan Reynolds hereby moves to dismiss the amended complaint with prejudice and without leave to amend, pursuant to Federal Rule of Civil Procedure 12b-6, moves to strike Exhibit A and moves for an award of attorney's fees pursuant to New York civil rights law. Okay. So here's the memorandum, which is actually where we get to all the interesting stuff. Okay, it's 38 pages, so it's a little longer than I thought, but it's not bad. Okay. Laura, well, you're the first to pop up with this. Well, I certainly try to be, like you guys know, I work from home, so I check on the docket throughout the day. Sometimes if I don't feel like anything's going to happen, then I won't look at it very frequently. But as I told you guys, Thursday was the deadline for a lot of these responses to the complaints. So like the amended complaints for Justin. Here we have a motion to dismiss. So I don't really know if they would have to file anything else in that regard by the 20th, but there's other parties that also will have to submit filings by the end of the day, Thursday, per the schedule outlined in the docket. So just Ricardo, thank you for $2. Hello, people. I hope you're doing well. I hope you're doing well, man. Thank you for being here. Okay, let's get into it. And as always, I just want to remind you guys, if you're new to my channel, I work in emergency psych and I work in healthcare. I help people with their insurance issues. Like if the insurance won't pay for their healthcare, I have to appeal on their behalf. So I'm not a lawyer. There's going to be lots of law tubers who go over this, I'm sure. So when it comes to some of the case law stuff, I will skim a little bit. But, we'll do the best we can here. All right. Blake Lively sued Jamie Heath, Justin Baldoni. It ends with us, Jennifer Abel, etc., the Wayfair parties. After they collectively launched a retaliatory social manipulation campaign to destroy and bury her because she privately spoke up about sexual harassment and inappropriate conduct that she and others experienced on the set of the film It Ends With Us. So what does Ryan Reynolds have to do with that, legally speaking, other than being a supportive spouse who has witnessed firsthand the emotional, reputational, and financial devastation Miss Lively has suffered? Nothing. Mr. Reynolds is a defendant in this action for one reason and one reason only. Because billionaire plaintiff Steve Sarowitz promised to spend up to $100 million to ruin Miss Lively and Mr. Reynolds. The First Amendment complaint that Sarowitz and his co-plaintiffs filed seeks to fulfill that promise by polluting this court's docket with hundreds of paragraphs of clickbait designed for an audience other than this court, with virtually no bearing on cognizable legal claims. Okay, you want to talk about something for an audience other than this court? It's this sentence right here in a legal document that's accusing someone of clickbait. So, pot, meat, kettle, if anything, right? That's fucking nuts. I can't believe that. Oh my god. Okay. Yeah, people are saying he definitely wrote this. That's what I was wondering. Did he write this script? All right. The Wayfarer parties have described the First Amendment complaint as their most recent attempt to put all the evidence before the court and the public. That is a damning concession, given the lack of any actual evidence supporting any legally cognizable claim against Mr. Reynolds. The Wayfarer party's so-called receipts include annotated excerpts, many with heavy redactions made by some unidentified person, of emails, text messages, videos, and photographs, such as large colored photographs comparing Mr. Reynolds' long hairstyle in a movie with Mr. Baldoni's long hairstyle at some point in his real life. But the First Amendment complaint is a pleading, not a gossip rag. And these so-called receipts fail to establish the requisite elements of a single one of the many causes of actions alleged against Mr. Reynolds. Oh boy. Just Ricardo, thank you for the 2. Every accusation is an admission with these people. Man, this is crazy. Oh. So I'm kind of like looking at this part right here where it says he's comparing the long hairstyle or whatever, large colored photographs comparing his hairstyle. And like we all know, because we're not stupid, that the Deadpool guy, the nice pool guy was based off of Justin. I mean, just look at the stuff that, you know, they had and that didn't even make it into the movie, right? So we had that video under 60 seconds, you know, the whole thing and all the scenes. And you can totally see it, especially when it's all laid out in front of you. And like, just don't pretend that people are stupid. Like, at least argue like, hey, you know, I might have done this, but it's not illegal or something like that. Because, you know, it very well may not be. I mean, I don't know. I don't think it is. But, I mean, I don't think it's a crime. I think it was tasteless, but whatever. All right. The Wayfarer parties attempt, but fail to assert 6 causes of action as to Mr. Reynolds. Each fails to plead facts sufficient to establish a prima facie case as a matter of law. For example, the plaintiffs collectively assert a claim for defamation without pleading a single complete statement or identifying the time or place of such statement, nor can they because no such defamatory statement exists. Further, the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. Reynolds allegedly called Mr. Baldoni a predator. But the First Amendment complaint alleges no plausible facts that suggest Mr. Reynolds did not believe this comment to be true. Instead, the relevant FAC allegations, FAC is First Amendment complaint, suggest that Mr. Reynolds genuinely, perhaps passionately, believes that Mr. Baldoni's behavior is reflective of a predator. Even if the FAC plausibly alleged that Mr. Reynolds called Mr. Baldoni a predator while believing the opposite, which it does not. The law establishes that calling someone a predator amounts to constitutionally protected opinion. And the FAC's thin-skinned outrage over a movie character, the satirical woke nice pool, does not even pretend to be tied to any actual legal claims. Instead, it falls into the FAC's general allegation of hurt feelings, which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfarer parties created and disseminated in the retaliation campaign they launched against Miss Lively in August of 2024. Oh, man. Kitty got your tongue. Thank you for the $3 super sticker. Appreciate it. 1 sec. I see someone in the comments saying Team Lively seems to be in panic mode. So this week, like I said earlier, is going to be kind of a marathon, not a sprint. I expect to see lots of responses and lots of dramatic filings and stuff like that. And don't get me wrong, that's like my Super Bowl, but I don't know if anybody's in panic mode per se, but they do have to provide an answer now. It's crunch time. All right. All the other claims fail for similar reasons. The Wayfarer parties say that Mr. Reynolds extorted them, but fail to allege that he received any money or property. They claim he interfered with a contract without identifying what that contract is, what provisions were allegedly breached, or even which of them were parties to it. They assert $400 million in damages without explaining anything about who suffered that loss, in what proportion as a result of which claims, or what proximately caused such losses. The FAC is long on hyperbole, prose, and claims, but devoid of any facts necessary to state ones recognized by law. It is, in essence, a burn book. A burn book filled with grievances attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the woman in his life and to hold her anguish and actually stand with her. God, these guys are cunts. All right. Anyways, there's a little footnote there in case you didn't know where they cite Justin Baldoni, Why I'm Done Trying to Be Man Enough TED Talk. So again, they're just hoping the shock value of using Justin's own word against him or being like that, ooh, what a burn, will like kind of overshadow everything else and make people think like they totally have the best point here, they're going to win, and that's not how the law works. But the thing is, like, this also feels very catered to the public that's reading this right now. It does not feel so far like a legal document to me, which is, by all accounts on my end, fine, because I'm here to be kind of more of an entertainer, to be honest. I mean, I talk about things from a layperson's perspective, but I'm not a lawyer, and I'm not seeing a way they're winning any brownie points with this other than they're kind of making good talking points for people who are reading it online. So, somebody says he's filing this as a PR tactic. That's all he does. It is required that they respond by the end of Thursday. So, like, they did have to respond, but they didn't have to respond with this garbage. So, let's continue reading the garbage anyway, shall we? I'm kind of, I don't hate garbage when it's entertaining and non-scented. Okay. The FAC is, in sum, a textbook retaliatory slap suit, and it should be dismissed with prejudice. Background. The Wayfarer parties have asserted a grab bag of claims against Mr. Reynolds and their FAC, including 1. Civil extortion, 2. Defamation, 3. False light invasion of privacy, 4. Intentional interference with contractual relations, 5. Intentional interference with prospective economic advantage, 4 and 5 together, intentional interference claims, and 6. Negligent interference with prospective economic advantage. The Wayfarer parties claim that they have suffered no less than $400 million in compensatory damages, plus mental pain and anguish and severe and serious emotional distress, not to mention hurt feelings, for which they posit they deserve additional compensation. So first of all, this right here, I claim no less than all of this in damages for having to read all this bullshit. But as far as the hurt feelings and emotional distress goes, is she not also claiming mental distress at some point? So should you really be making fun of hurt feelings and mental distress if your wife is also suing for the same thing? No? Can anyone help me connect the dots there? Why is it okay for him to be hurt feelings and your emotional distress is not important or it's silly, but then also my wife's emotions and her mental health, So pick a side. I don't know. Okay. Despite its length, the FAC alleges only a few isolated acts by Mr. Reynolds. With respect to the defamation claim, the FAC does not plead a single complete statement published by Mr. Reynolds. The only hint about the purported statements that are alleged to form the basis of the defamation claim is the following assertions in paragraph 325. The Lively parties made one or more statements to persons other than Wayfarer, including, without limitation, to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and that the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. I don't see an issue there. Only 2 allegations in the FAC even generously match that description with respect to statements purportedly published by Mr. Reynolds. Okay. Her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni. And then the second one they have here is Baldoni later received word that during the premiere of his movie Deadpool and Wolverine, Ryan Reynolds approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator. And at a later date demanded that the agent drop Baldoni. And if you guys remember that leaked audio from Freakonomics that Colonel Kurtz and Citizen Journalist on Twitter had come across and posted. That looks pretty bad for them. So. Apart from those two statements, the totality of the FAC's allegations against Mr. Reynolds are that Mr. Reynolds, 1, demanded that the Wayfarer parties publicly apologize for so-called mistakes during production of the film, 2, was present during a meeting at the apartment that he shares with Miss Lively, at which he praised Miss Lively's version of a scene in Mr. Baldoni's presence. Okay, I just want to clarify, meeting at the apartment is the penthouse. The penthouse! We all know how I feel about the penthouse people, okay? Like, just... I love when they call it the apartment. I'm like, no. I've lived in apartments. You live in a castle. Don't even give you that. All right. Allegedly contributed some writing of his own to the script, admonished Mr. Baldoni for asking about Miss Lively's weight, and demanded that a scene be removed from the film. 5, attended a meeting with Miss Lively to address her allegations of sexual harassment on set, and demanded that Mr. Baldoni apologize for his conduct. 6, unfollowed Mr. Baldoni on social media, and 7, included the Nicepool character in Deadpool and Wolverine that the FAC alleges was meant to satirize Mr. Baldoni's persona as a woke feminist. What wasn't it? All right. So this part here about allegedly contributed some writing of the script, Blake did say to an interviewer, I can't recall which one, that Brian had written some of that. So, like, you can't just pretend that she didn't say that now. It's so satisfying watching you have fun reading this, dude. Yeah. All right. Legal standard. In reviewing a motion to dismiss under Federal Rules of Civil Procedure 12b-6, the court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor. Okay. However, this requirement is inapplicable to legal conclusions, and threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. A complaint must offer more than labels and conclusions, or a formulaic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. Argument. And remember, guys, they're arguing to dismiss this complaint, and they do not want the judge to give the Wayfarer parties a chance to amend as well. So, argument. 1. The claims against Mr. Reynolds fail under both New York and California law. While the Wayfarer parties appeared to agree with Miss Lively that California law applies to the allegations in the case she filed, that does not answer what law applies to the Wayfarer parties' claims against Mr. Reynolds. The choice of law may vary by defendant and also by specific claim, even against the same party. Okay. To the extent that there is no conflict between California and New York law with respect to the Wayfarer parties' claims against Mr. Reynolds, the court may simply apply New York law. To the extent there is a conflict, as there may be with respect to the extortion, false light, and negligent interference claims, New York law applies to the claims against Mr. Reynolds because New York is the jurisdiction having the greatest interest in those claims, given the way the Wayfarer parties pled the claims against him in the FAC. The FAC's allegations as to Mr. Reynolds focus solely on conduct that occurred in New York while he resided in that state. Whereas here, Mr. Reynolds alleged torts are conduct regulating rather than loss allocating, the law of the state where the conduct occurred will typically apply. Okay. And I remember somewhere in one of the other responses to a motion to dismiss, I can't remember if it was against the Times, I think it was the one against Sloan, where they had talked about how filming and a lot of this stuff took place in New Jersey, so it wasn't even in New York, it wasn't in California. So yeah. Gamer Girl says, funny he wants to dismiss now that Jackman to be disposed. Well, so the thing is, like, of course they want it dismissed. You know, they don't want to fight Justin in court because, like, they're going to fight on the side of, like, Blake, you know, filed her lawsuit. They're going to be going to court for that. So I kind of understand that they want to get out of also having to answer to his complaint. So it's kind of, I don't think it really has anything to do with Hugh Jackman, to be honest, because I think that they were always going to try to dismiss this, or Ryan Reynolds was always going to try to dismiss this or get himself out of the claim. Not to say that he wouldn't if under different circumstances, but he did have to, you know, respond, and he wants his response is, "I want out," basically. Okay. As set forth below, however, each of the claims fail under both New York and California law, and therefore the FAC should be dismissed with prejudice against Mr. Reynolds. Okay, now we have number 2. The court should dismiss all of the 6 causes of action as to Mr. Reynolds with prejudice. The FAC fails to state a claim for defamation against Mr. Reynolds. The defamation claim fails as a matter of law. It is fatally and facially deficient because the FAC does not identify a single allegedly defamatory statement published by Mr. Reynolds, including either of the predator statements. Moreover, to state a claim for slander, a plaintiff must plead 1, a defamatory statement of fact, 2, that it's false, 3, published to a third party, 4, of and concerning the plaintiff, 5, made with the applicable level of fault on the part of the speaker, 6, either causing special harm or constituting slander per se, and 7, not protected by privilege. And then the footnote here, number 4, regarding the single allegedly defamatory statement. It says, Mr. Reynolds joins the argument in the Sloan and New York Times motion to dismiss that the FAC must be dismissed for impermissible group pleading. And we heard so much about that the other day, so hopefully we won't have to read that much more. Okay. The FAC fails to plead the claim in virtually every respect. All right. We have 1, the Wayfarer complaint does not sufficiently identify any defamatory statements published by Mr. Reynolds. The court should dismiss the defamation claim as to Mr. Reynolds because the FAC does not include allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself. As this court has noted, it is only by pleading the substance of the purported communication that a defendant can challenge and, upon a motion, the court can determine the essential elements of a defamation claim under New York law, including whether the statement was false, whether it was capable of defamatory meaning, and whether it was of and concerning the plaintiff. And here in footnote 5, it says the court must analyze the defamation claim under the rubric of slander because the FAC alleges only oral statements as to Mr. Reynolds. Okay. The FAC fails to sufficiently plead the substance of the predator statements. I like that predator statements is like a proper thing now. Which are the only ones relevant to the defamation claim as to Mr. Reynolds. As to the agent statement, the FAC does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent statement. Just got here, but asked 2 lawyers called it. They said this was going to be the next step for them, just so they can ask for a stay in discovery. Well, yeah, and like I said, everything like response-wise has to be filed by end of day Thursday. So, but yeah, I like those guys. They're pretty cool. I'm sure they'll be going over this later too, or soon probably. They're pretty fast. All right. As to the agent statement, the FAC does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent statement. Okay. See paragraph 8, and this is paragraph 8 of Justin's complaint, stating only that Mr. Reynolds used the term sexual predator to describe Mr. Baldoni during a phone call with Mr. Baldoni's agent. I mean, that seems like kind of a big deal, especially if the agent then turns around and fires him for it. I mean, and Ari Emanuel was not subtle about what happened in that leaked audio, so I don't know. The absence of these details makes it impossible, for example, to determine whether the statement falls within the applicable 1-year statute of limitations for defamation. The sole allegation as to the executive statement provides only slightly more detail, namely that Mr. Reynolds and an unnamed executive at WME, yeah, gosh, I wonder who that is, had a conversation during a movie premiere about Mr. Reynolds. Deep disdain for Baldoni, suggesting the agency was working with a sexual predator. The FAC does not allege what precise term Mr. Reynolds used in this alleged suggestion, the sentence in which he allegedly suggested it, or any information about the context of the conversations, other than that one of them was about how much Mr. Reynolds dislikes him for having sexually harassed his wife. Such bare bones pleading fail to satisfy Rule 8 and warrant dismissal of a slander claim. Okay. 2. The predator statements are not defamatory because they are constitutionally protected opinion. All right. 1. The predator statements are unactionable opinion. And then they quote here, as a threshold matter, because there is no such thing as a false idea, courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory. Instead, opinions receive absolute protection under the New York Constitution. Okay. The predator statements constitute unactionable opinion because they have no precise meaning, are not capable of being objectively characterized as true or false. Well, I don't know if that's true. I don't know. And are merely a general reflection of the speaker's viewpoint. As another court in the district has explained, courts have recognized that words like scum, predators, greedy, crooks, and criminals preying on street art culture are vague, imprecise statements of hyperbole considered non-actionable opinion. So what we're saying here is that using those words to describe somebody would not then be enough to file a lawsuit. Is that what we're saying? So like if I were to say Ryan Reynolds is a scummy predator, a greedy crook, and preys on street art culture, that's fine. Okay, just checking. I know that's not exactly what that means, but still. All right. Predator really doesn't seem like a vague, imprecise statement to me. I mean, there's a... Oh my gosh. Okay. I won't get into that too much, but... Here's a footnote we probably should read. It says, to determine whether a statement is fact or opinion, courts will generally consider 3 things. 1, if the specific language has a precise meaning which is readily understood. I mean, I kind of feel like it does, but that's just me. 2, whether the statements are capable of being proven true or false. And 3, whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal to readers or listeners that what is being read or heard is likely to be opinion, not fact. I don't know. It sounded like that was a pretty like factual statement. Like he's, but that's just me. You would have to hear like the lawyers go over this one to see like whether the legalese here kind of makes sense and like, was it really okay for him to talk like that? But I'm here because I like to talk about these things, as you guys know, from a layperson's perspective. So I don't really care if he can get away with having said that legally on like a technicality or what specific language was used and where and how it was said. Like that doesn't matter to me. I think that even if the court were to let this go, I still think it's a scummy thing to do. It's a shitty thing to do. It's garbage behavior. It just shows that powerful people could get away with saying or doing anything to destroy anyone they don't like. And so I don't think that really like it might, help their case in court. But to me and to a lot of the public, it just makes you a really shitty person. And if you don't ever have to face justice for it, then that just makes people hate you even more, to be honest. So, all right. Use of colorful language such as predator, victimize, or face of evil are not actionable in and of themselves. They're citing another case there. Okay. Here's one they cite where it says calling someone evil or an animal or shameless is hyperbole. Well, those seem more obvious though than saying predator, because when you say predator, I feel like we all have a preconceived notion of what that means, right? Okay. While Mr. Baldoni may not appreciate being called a predator, those hurt feelings do not give rise to legal claims because name calling does not reflect a fact but a non-verifiable view. But what if you go to that person's agent, accuse them of being a sexual predator and get them fired? Does that not mean anything? Like, I feel like it should. And if it doesn't, like I said, the reason I go over these court documents is because I feel strongly that even if something is technically legal, doesn't mean it's right. So let's not pretend that it's not a terrible thing to do to call someone a predator and get them fired when they are not a predator. So these First Amendment principles ought to be obvious to, and even celebrated by, a group of litigants who have spent most of the past few months calling Mr. Reynolds and his wife bullies and liars. Okay. The FAC fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact capable of being proven false rather than a pure opinion that is not actionable under the laws of New York. Okay. It was his agent that Ryan said it to? Correct. And the agent came out then on a podcast which the audio of which was somehow lost, but then later leaked. And it's pretty bad. It looks pretty bad for them. All right. Okay. The FAC fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact, capable of being proven false rather than a pure opinion that is not actionable under the laws of New York. While the FAC fails to provide sufficient details about the predator statements, which alone is grounds for dismissal, the limited context it does provide militates in favor of a finding that they are assertions of opinion. The FAC alleges that Mr. Reynolds made the predator statements during a phone conversation with Mr. Baldoni's agent and at a movie premiere during a conversation with a WME executive during which Mr. Reynolds was expressing his deep disdain for Mr. Baldoni, which is utterly fatal under the opinion doctrine because it is plainly reflective of Mr. Reynolds' unabashed negative opinion of Mr. Baldoni's character. Well, saying you don't like someone is one thing. That's an opinion. If I were to say I think Ryan Reynolds is acting like an unabashed piece of shit, that's an opinion, okay? But if I were to come out here and say Ryan Reynolds is a sexual predator, that's a little different. Especially because I know I don't have any reason to be saying that as a statement of fact, right? Like, I don't have any evidence that he's a sexual predator. So if I were to come out here and be like, hey, Ryan Reynolds' boss, Ryan Reynolds is a sexual predator, I feel like that would be a problem, no? Okay, I gotta stop saying those words. YouTube does not like them. Okay. Mr. Reynolds has a First Amendment right to hold Mr. Baldoni or any man who Mr. Reynolds believes sexually harassed his wife in deep disdain. Sure, but you don't get to be the arbiter of justice for it when you have no proof that anything like that happened, and in fact, evidence suggests otherwise. Okay. And the FAC does not allege any plausible facts that would remotely suggest, let alone establish, that anyone interpreted Mr. Reynolds' statements as reflecting anything other than his genuinely held belief about Mr. Baldoni's character. The court should dismiss the defamation claim as to Mr. Reynolds with prejudice because the predator statements are expressions of opinion that deserve absolute protection by law. Okay. And then here, this is going to piss me off, isn't it? It says, if the predator statements are not opinion, they are substantially true. Oh boy. Okay. Even if the predator statements were verifiable as fact, they are not actionable as defamation because they are substantially true. The Second Circuit has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss. Because falsity is an element of New York's defamation tort, and falsity refers to material not substantially true, the complaint in this case must plead facts that, if proven, would establish that the defendant's statements were not substantially true. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. When the truth is so near to the facts as published that fine and shaded distinctions must be drawn, and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance of the challenged statements be true. Okay. And again, I just want to emphasize that even if all of this is technically legal and they use the right words in the right context, you still know what kind of person this guy is, because he's totally fine with what happened. He's totally fine with getting someone fired and fucking up their entire life, you know? All right. The FAC includes numerous references to conduct that a reasonable observer could well consider predatory. In particular, the FAC relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books. Okay. Those materials with which anyone who knows about Mr. Baldoni would be familiar include numerous admissions to behavior that could reasonably be described as predatory. See, for example, Jane Randall, Boys Will Be Human, a talk on healthy masculinity with Justin Baldoni, YouTube, March 7th, 2023, saying that I'm sure I have crossed boundaries and lines in my teens and 20s, not even thinking about it simply because of the porn I was consuming. What is... Jesus Christ, I was right. This is going to piss me off. All right. The Man Enough podcast, Jamie Camille, I might be saying that last name wrong, changing the narrative. I grew up and had an addiction to porn. I was introduced to porn at 10 years old, formed these neural pathways in my brain, and it caused me to see the world very differently. Okay, so that's going to be like a really hard thing to talk about, like a really vulnerable thing to come out and talk about, especially when you know it might hurt your reputation as, you know, somebody who's a public figure. And it's just the fact that they're using this against him is like really irritating me right now. Because let's be honest, like most people who struggle with porn addiction, I feel like they're probably pretty unlikely to come out and talk about it and help other people who struggle with it, because that's such a, I don't know, you just look at somebody who would say that. Like, I feel like a lot of people would look at somebody who would say that and be like, oh my God, you're disgusting. You know what I mean? And that's not necessarily true. Yeah. Let's see. Where's this footnote for? Footnote 10. Okay, it says, so they're just citing things from paragraph 38 of the First Amendment complaint, admitting to relaying distributors' concerns, the widespread social media criticism, admitting suggesting Miss Lively's character orgasm during the scene. Well, they're writing a sex scene. Like, what's your problem? 94, admitting to tell Miss Lively that the onesie she was wearing underneath her jacket was sexy. Again, that seems to be something that could have been taken out of context. 119, admitting to casting his friend as the obstetrician in the birth scene, where he would be in close proximity to her nearly nude genitalia. So we know that the obstetrician, the friend who played the obstetrician, was like an accomplished actor, more than qualified for the role. So it's not like he just hired a random friend and was like, hey, look at this chick's vagina. You know what I mean? Like, that's not what happened. Let's stop pretending. Okay, we're going to keep moving on here. We're talking more about the porn addiction there. Okay. And they're just kind of quoting him in all his stuff in this paragraph. It says, and for me, you know, it was really tricky because I think there's a link between rape culture and porn culture. I'm not calling out the porn industry. I'm calling out my relation to it. But I do believe that especially the porn that young boys are watching is very violent. And because no one ever sits us down and teaches us about consent, we learn it through porn. So again, opening up and being vulnerable about this stuff, like, that's not something that you should shame someone for. He's not saying that he, you know, did anything to hurt anyone. But he's just saying, I believe that this is hurtful and this is why, and that it can lead to bad behavior and this is why. So, dude, like, I have a real problem with that. Okay. And so they're basically just quoting him, like, stuff from his podcast and shit that has absolutely nothing to do with this motion to dismiss, in my opinion. I have no idea why they're mentioning this stuff. Like, it's pretty much just to make him look bad. So it's very strange because in the first, I think it was like the first page, they're talking about how he's writing this for, you know, like a different audience or whatever. And then here they are basically just slamming his character down this entire page. For what? For what? Okay. And then here he's quoted saying, you write as a black man or you as a woman have had to put up with a lot of shit from people that look like me and or from me your entire life. And again, it could be a laundry or it could be microaggressions for racism or sexism, whatever it is, I've done all of them. So again, I don't love that they're taking this out of context because you could make someone sound really bad with that, yeah? But they're talking about, like, in my opinion, I'm obviously seeing this out of context. It sounds to me like he's talking about, like, stuff that he did wrong in the past or his bad behavior in the past, because subconsciously, like, we see all the time articles, interviews, stuff, whatever, people talking about, like, unconscious racial bias and unconscious sexism and stuff like that. Like, like your brain is just like used to making these assumptions about people. And so I feel like that's what he's saying there. But the fact that they're using it out of context to make him look like some sort of predator is really, in my opinion, shitty behavior. So, okay. While it's unclear what predator means to an average listener, well, yeah, if you're stupid, what? It is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to be a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in sexual relationships. So, again, he's talking about his teen years and stuff up here. I don't think he was saying like, oh, last week, by the way, I was a real shitbag. You know what I mean? Like, he's talking about his past and the work that he's done to become a better person. Jesus Christ. This is so bad. Okay. Okay. Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegation that he is a predator, but the law offers no principled basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. Okay. Well, guys, I'm going to be honest. When I was really young, I kind of ran around naked, you know? Like, I wanted to be Tarzan. I ran around with only, like, bottoms on. I was like, I'm Tarzan now. I even cut my own hair. My mom was furious. So would that then make it correct for someone to call me some kind of exhibitionist or something? Like, what? Okay. Just saying. I feel like there's a big difference than of like talking about your behavior as a teenager or a child or when you're growing up than like talking about yourself last week or last year. It's just not the same to me. But again, you know, it may be legal what they're saying, but to me, it seems wrong, okay? Like morally incorrect to be doing this right now. So, all right. Tarzan's gone now, so let's keep reading. Okay, they're setting a case there. It would be perverse to permit Mr. Baldoni to build an entire brand, complete with a podcast, TED Talk, and books, off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million of simply pointing out in private what Mr. Baldoni has bragged about in public. Okay, in private, but not really, because it was to his agent, like to his employer, or like not his employer, I guess, but what would you call it? I don't know. To someone who plays a large part in his career success or like opportunities and shit like that, I guess. Okay. In light of Mr. Baldoni's own public admissions, of which the court can take judicial notice, okay, and they're citing more case stuff here. The FAC fails to plead special damages. Dismissal of the defamation claim is warranted because the FAC does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient particularity to identify actual losses. And then they're quoting a case here. This particularity requirement is strictly applied as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity. Okay. Far from fully and accurately identifying any harm that flowed directly from the injury to reputation caused by the predator statements, the FAC generally claims at least $400 million in compensatory damages without explaining what amount, if any, of that astronomical sum allegedly was suffered by Mr. Baldoni versus any of the other Wayfarer parties, or otherwise caused by the predator statements. Okay. The court should strictly apply the particularity requirement and dismiss the defamation claim for failure to allege special damages with the requisite degree of specificity. 4. The FAC fails to plead facts demonstrating actual malice. As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Reynolds uttered the predator statements with actual malice. In other words, that Mr. Reynolds, in fact, entertained serious doubts as to the truth of his publication. Okay. The FAC's conclusory assertion that the lively parties, defined to include Mr. Reynolds, knew the statements were false or had serious doubts about the truth of the statements is a threadbare recitation of the legal element that is insufficient to sustain the law's heavy burden on defamation plaintiffs. Okay. Nor do claims of animus like Mr. Reynolds' deep disdain for and rage and wrath directed at Mr. Baldoni sufficiently plead actual malice. And then they quote here a case that says actual malice does not simply connote ill will or spite. Actual malice has nothing to do with bad motive or ill will and may not be inferred alone from evidence of personal spite, ill will, or intention to injure on the part of the writer. Okay. It would be inconsistent with the FAC to find that Mr. Reynolds uttered the predator statements with actual malice. Indeed, there is not a single plausible factual allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the FAC alleges, well, I mean, that could also be something that might come up in discovery if you're subpoenaing phone records, text messages, stuff like that. So I guess there is one way to find out, yeah? To the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's woke feminist facade in Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct. The deep disdain that the FAC alleges Mr. Reynolds feels towards Mr. Baldoni concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of actual malice. Now, that's something I'd be interested to hear from the two lawyers or from Omar or any other attorneys that are covering this case, what they think about that. So I'm sure I'll be listening in later. All right. 5, the predator statements are not of and concerning any Wayfarer plaintiff other than Mr. Baldoni. The predator statements refer solely to Mr. Baldoni and not any of the other 6 Wayfarer parties. To the extent that the FAC intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni, it requires dismissal because the predator statements are not of and concerning any of them. Somebody says, what is Omar's YouTube channel? Omar's YouTube channel is The Tilted Lawyer. And I'm sure he'll be on tonight. And I'll probably join him. So you guys should come join us. All right. I'm skimming through some of the case stuff here, like I said, guys. B, the Wayfarer complaint fails to state a claim of false light. Okay, the FAC fails to state a claim of false light as a matter of law under either New York or California law. There is no tort of false light invasion of privacy under New York law, and the court need not engage any further analysis in order to dismiss such a claim. While California law recognizes claims of false light, dismissal is required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. While the FAC's false light claim suffers from the same fatal lack of specificity described above, it also fails because it appears to rely entirely on the alleged public disclosure of information on which the defamation claim is based. Finally, even if all of that were not dispositive, the false light claim fails as a matter of law for all the same reasons that the defamation claim cannot survive dismissal. Okay. C, the Wayfarer complaint fails to state a claim for civil extortion. The civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize extortion as a tort or as any private right of action. Similarly, although California federal courts have divided over whether California recognizes a civil cause of action for extortion, sorry guys. The most that California state courts have recognized under the heading of civil extortion is a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution, where the threat of prosecution is made with the knowledge of the falsity of the claim. Because that cause of action is a form of fraud, it must be pleaded with particularity under Rule 9b. The FAC is devoid of any allegations, much less particularized allegations, that Mr. Reynolds obtained any money or property from any of the Wayfarer defendants or made any wrongful threat of prosecution, much less with knowledge of the falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The FAC fails to allege that Mr. Reynolds either 1. Obtained any property or consideration from any Wayfarer defendant, because of course he did not, or 2. Did so through a wrongful use of force of fear. I don't know, that's a little questionable there. I feel like this is a little questionable. As to like the claim they're making, because, you know, as far as the extortion stuff goes, he certainly would have obtained something from the way that he and his wife kind of forced them to do what they wanted. Otherwise, they wouldn't proceed, or like would basically destroy everything. Not in those words. Obviously, that's not the words that they used, but we kind of know how that went down. Crowd Red Eye kind of says what I was thinking. Hijacking a movie is generally done for profit. Yeah. I don't know. I've never tried it before, but, you know, there's always tomorrow. Okay. D, the intentional interference claims must be dismissed. The tortious interference claims are duplicative of the defamation claim. As an initial matter, each of the tortious interference claims must also be dismissed as duplicative of the defamation claim. It quotes, New York law considers claims sounding in tort to be defamation claims where those causes of actions seek damages only for injury to reputation or where the entire injury complained by plaintiff flows from the effect on his reputation. Whether Mr. Reynolds' alleged statements to WME are actionable in light of their claimed effect on Mr. Baldoni's reputation must fall, as well, under the pleading requirements for defamation. Nonetheless, each claim fails on its own terms as well. 2. The FAC fails to state a claim for intentional interference with contract. Okay. Whether under New York or California law, intentional interference with contractual relations requires that the plaintiff allege 1. The existence of a valid contract between the plaintiff and a third party. 2. Defendant's knowledge of said contract. 3. Defendant's intentional procurement of the third party's breach of the contract without justification. 4. Actual breach of the contract. And 5. Damages resulting from the breach. To survive a motion to dismiss, a plaintiff must specifically plead the existence of a valid contract and must identify what provisions of the contract were breached as a result of the acts at issue. Furthermore, because a claim for tortious interference requires a showing of breach, contracts that are terminable at will generally cannot provide the basis for such a claim. Okay. A plaintiff must also plead specific allegations of the defendant's knowledge of the contract, including some knowledge of the terms and conditions. The FAC fails each of these requirements. The sole contract alleged in the complaint is a contract between Wayfarer and William Morris Endeavor WME, but the FAC does not allege any details about the contract, including which parties it allegedly bound, surely not all 7 Wayfarer parties were parties to it, what the contract's terms were, or what provisions were allegedly breached. Strikingly, throughout the entire FAC, there is not a single allegation that WME breached its contract with any Wayfarer party, much less a description or quotation of a contractual term allegedly breached. Okay. Instead, the Wayfarer parties allege solely that, upon information and belief, Ms. Lively and Mr. Reynolds induced WME to cease performing under its contract. But the cessation of performance is not the same thing as a breach of contract, and the Wayfarer parties, who have alleged the existence of this contract, are presumably in possession of its full terms, have utterly failed, after multiple tries, hundreds of pages, more media interviews than can be counted, and a publicly launched website, to identify any contractual provisions that they claim WME breached when it allegedly ceased performance. I mean, dude, I mean, this is not about the interviews and the website, so let's not go there, but I mean, I guess if you really want to get in a little pot shot, you got it. That's a little silly, though. Okay. The FAC fails to state a claim for intentional interference with prospective economic advantage. In the absence of an allegation that a specific contract was actually breached, the FAC must satisfy the more stringent requirements for a claim of intentional interference with prospective economic advantage. It does not. To state such a claim, a plaintiff must allege, 1, it had a business relationship with a third party, 2, the defendant knew of that relationship and intentionally interfered with it. 3, the defendant acted solely out of malice or used dishonest, unfair, or improper means. And 4, the defendant's interference caused injury to the relationship. Once again, the sole economic relationship alleged in the FAC is between Wayfair and WME, without specification as to which of the Wayfair parties had such a relationship. Well, they must be bad at math if they can't count the interviews. I guess so, man. All right. The FAC does not even attempt to allege that Mr. Reynolds acted solely out of malice, as is required to survive a motion to dismiss. But the FAC itself asserts that Ms. Lively and Mr. Reynolds were motivated, at least in part, by a desire to seize control over a film production. Taking that allegation as true, as the court must at this stage, whether or not it is true, such a motive akin to normal economic self-interest is inconsistent with the sole purpose of inflicting intentional harm and is insufficient to state a claim for tortious interference with prospective economic advantage. Nor does the FAC allege that Mr. Reynolds employed any wrongful means. To satisfy that element, as a general rule, the defendant's conduct must amount to a crime or an independent tort. But there is nothing in the FAC that amounts to an allegation of wrongful means. At most, the FAC alleges that Mr. Reynolds approached an executive at WME and suggested the agency was working with a sexual predator. At most. Again, I know that they are talking in like technical legal terms and stuff, but from a layperson's perspective, reading this document, saying, well, at most, he approached an executive and just casually accused the guy of being a sexual predator. Like, wow, that's no biggie, guys. Chill out. Okay. And at a later date, demanded the agent drop Baldoni. But sharp language such as insulting a defendant by calling them a thief and a scumbag is not wrongful or culpable conduct sufficient to qualify as wrongful means. Okay, that's not exactly the same, but okay. And pleading the presence of false statements alone is not enough to support a claim for tortious interference. The FAC lacks a single allegation suggesting, let alone establishing, if taken as true, that Mr. Reynolds' alleged demand was anything other than an expression of sincerely held beliefs, which are neither criminal nor tortious under the First Amendment. The FAC fails to state a claim for negligent interference. The negligent interference claim must be dismissed because there's no claim for negligent interference with a prospective economic advantage under New York law. And even under California law, a negligent interference claim is cognizable only where the defendant owes the plaintiff a duty of care, which the FAC does not allege. 5, the FAC fails to allege proximate cause. Each of the tortious interference claims must also fail because the FAC does not allege that Mr. Reynolds' alleged conduct proximately caused WME to cease performance. Okay. The FAC is silent as to how Mr. Reynolds, someone who does not own or control WME, could plausibly cause WME to cease performing its contract with Baldoni. That's a joke, right? And again, that leaked audio that Colonel Kurtz and Citizen Journalist shared, it sounds pretty bad. That's going to come into play, I think. That's not good. All right. The Wayfair parties have failed to allege any damages. Aline Bonifazi says his side would argue that it's up to the jury members to determine if it's a statement of fact or opinion. Yep. Okay. Finally, and regardless of the theory under which their claims are brought, the Wayfair parties have failed to sufficiently allege damages. Merely alluding to damages in a conclusory fashion does not suffice. The FAC repeatedly asserts that the Wayfair parties were harmed and prays for a damage award of at least $400 million. Don't forget about the hurt feelings, guys. But nowhere explains how or how much any of the Wayfair parties were actually damaged by any of the alleged conduct in the complaint. An allegation that a claimant suffered damages without particular facts as to how she was damaged does not satisfy Twombly and Iqbal. Is that how you pronounce that? I'm not sure. All right. The FAC has nothing more than a bare assertion that the Wayfair parties were harmed and an unexplained demand for $400 million, but that is not enough to state a claim. E, the Wayfarer complaint fails to allege conspiracy liability. Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the FAC attempts to hold him liable on a conspiracy theory. That attempt fails. Under both California and New York law, a civil conspiracy theory requires that a plaintiff allege 1. An agreement to participate in an unlawful act or a lawful act in an unlawful means. I almost said mess, which kind of seems to make more sense here. An overt act performed in furtherance of the scheme, and 3. An injury caused by the overt act. Conclusory allegations do not suffice. To survive a motion to dismiss, a complaint must contain more than general allegations in support of the conspiracy. Rather, it must allege the specific times, facts, and circumstances of the alleged conspiracy. Here, the FAC pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement, and, as discussed supra, any damages. Even under the liberal pleading standards of Rule 8, a complaint must do more than assert the defendants agreed to commit a tort. Okay. But that is all the FAC can muster. Okay, so they're talking about this here. Okay. Plaintiff's complaint largely fails to attribute specific, and this is a quote from another case. Plaintiff's complaint largely fails to attribute specific actions to any of the parties and makes no specific allegations supporting the existence of an agreement between them. Without such a factual basis, plaintiff's conclusory allegation is insufficient to support a claim of conspiracy. Okay. Read individually or as a whole, the FAC allegations that Mr. Reynolds participated in conspiracy to engage in tortious conduct against any of the Wayfarer plaintiffs are utterly conclusory. Speaking of conspiracy, wasn't the JFK files supposed to be released today? Someone remind me about that. My ADHD is showing. Anyways, they amount to bare assertions. Asserting that Miss Lively, working with her husband, conspired to harm the Wayfarer parties by advancing a narrative in the press. Yeah. Unsupported speculation. Alleging that Mr. Reynolds apparently joined a campaign to extract concessions and creative control over the film. And pure boilerplate, reciting elements of civil conspiracy liability. Appearing to recognize this deficiency, the Wayfarer parties confine each of their allegations of conspiracy to information and belief. But that only confirms that the Wayfarer plaintiff's conspiracy allegations fall short, because claims made solely on information and belief are insufficient to sustain a conspiracy theory. There is accordingly no basis to hold Mr. Reynolds liable on a civil conspiracy theory for any of the conduct alleged in the FAC. 3, the court should award Mr. Reynolds attorney's fees pursuant to New York's anti-SLAPP law. So basically, they're saying that this should be dismissed, and also you should pay Ryan Reynolds for the attorney's fees of him having to deal with this mess, is kind of what they're saying here. Mr. Reynolds is entitled to attorney's fees under the substantive fee-shifting provision of New York's anti-SLAPP statute. Okay. You're saying that it applies to the FAC for similar reasons to Sloan and New York Times, who also made a motion to dismiss. Okay. Both of which Mr. Reynolds joins and incorporate by reference. Section 70A mandates a fee award in Mr. Reynolds' favor because, as discussed above, the FAC asserts causes of action against him based on communications and conduct in furtherance of an issue of public interest, namely Mr. Baldoni's and Mr. Heath's harassing workplace conduct and the subsequent retaliation, and cannot survive a motion to dismiss for failure to state a claim. Okay. Although this court reached a seemingly different conclusion in Brady v. NYP Holdings, Mr. Reynolds respectfully submits that the reasoning of Bobolinsky rather than Brady should be control here for 3 reasons. Okay, so what did Bobolinsky say? Hang on. He must have cited it up here. Okay, so I guess it must have been in a different document, but we'll skim over that because, like I said, guys, the lawyers are going to go through this and they'll get to the case law stuff a lot better than I will. All right. First, in Brady, the defendant requested anti-SLAPP fees in a single footnote that did not analyze whether 70-A1 applies in federal court, and the court accordingly did not have an opportunity to confront the arguments presented here or discussed in Bobolinsky. I hope I'm saying that right. Bobulinski. Okay. Motion to dismiss at 17. Let's see. Brady v. NYP Holdings. Second, Brady was decided before the New York case is confirmed that Section 70A1 makes attorney's fees available not as a sanction, but wherever a SLAP claim is dismissed for failure to state a claim. Okay. As interpreted by the New York courts, 70-A1 is not a sanction, but an exception to the American rule applicable to a class of cases defined by state law. For that reason, Brady's reasoning that Federal Rule 11 answers the question covered by his Section 70A1 has been overtaken by intervening New York law. Third and finally, it is well settled that the state fee shifting statutes are substantive laws that must apply in diversity cases. Okay, let's skim down here. The court should strike Exhibit A, and that's the timeline of evidence attached to the First Amendment complaint, to the Wayfair complaint, or at a minimum, disregard it. Mr. Reynolds joins the argument in the Sloan motion to dismiss, moving the court to strike the First Amendment complaint's Exhibit A. As this court has recognized, permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint would do considerable damage to Rule 8A's notice requirement, including by requiring a defendant to hunt around in voluminous materials to figure out what the plaintiff alleges is relevant and support its claims and what is extraneous. Even if the court does not strike Exhibit A, it cannot properly consider it to evaluate whether the FAC sufficiently states a claim. Conclusion: all claims against Mr. Reynolds should be dismissed with prejudice and without leave to amend, and the court should award Mr. Reynolds his cost, including attorney's fees incurred as a result of the consolidated action. Okay. So that was not terribly long, not a 5-hour reading like some of these amended complaints and stuff like that, but it's longer than I thought it would be. 1 second here. Okay, got it. Why don't you take a poll on that? I'm leading Ryan, though. Wait, what are we talking about here? Where's Crow? I can't figure out who's the lowest out of the two. Well, Ryan does look good for the pretty fucking low. Dude, I don't know. That's a tough one. All right, guys. I'm going to keep checking this docket because I'm assuming there might be some more stuff that comes up today. If not, then the next 2 days may get a little packed. We'll see. Like I said, there's lots of notices of appearances by lawyers coming in. That was just due to filing issues. So there's nothing really new there to see. But yeah, there'll be a few new documents on for today's date, but this is the only thing that was really super important in my opinion. So you're the best, Lauren, always on top of these documents. Thank you. No, thank you for watching. Thanks everybody. I appreciate it. Okay, so I'm sending you over to my friend who is doing a live baby goat watch. Please tell them Lethal Lauren 904 sent you, and maybe leave them some goats emojis or something, just as a favor. And then I will, in return, I will continue to read these documents live for you guys. Okay? All right. I'll see you guys soon. I got to get back to work a little bit, and I have a feeling I'll be seeing you later tonight. So, bye.